Okay. I don't know how far Your Honor got into the file. This matter's been set over a number of times. This is on for Mrs. request for a motion for invalidity or an annulment. My client has been working with the Guatemalan government, essentially, court systems down there to try and gather documents from his divorce prior to these parties' marriage. It has been extremely difficult to gather those documents. I was able to receive pictures of documents entirely in Spanish. I'm working with his attorney in that case. Last I had heard from him, they're needing a hearing to release those records of some sort. Again, I don't know. I don't practice in Guatemala, but that's the last update I have. So unfortunately, I still don't have those documents. And that's what we had last set this matter over for, is for me to obtain those documents from Guatemala in order to present them to the court.
I don't see, is Mr. Chen represented?
That's my client, Your Honor.
Oh, is Miss, is it, how do you say the last name? Rakik?
Yes.
Oh, okay, she's in the courtroom.
Yes.
All right. So, I guess, Miss Bliss, what is the time frame? It looks like we were last here April 23rd for the same reasons that, an attorney was hired in California to get some documents. Then there was documents that need to be translated. So how much time do you think you need to get those documents sorted?
As much of a stretch as it is, I am going to ask for 6 weeks potentially. And I know that's kind of the same timeline we had last time. I can, as an officer of the court, say that I, again, got a picture of those records just before the last hearing. I was anticipating those being received relatively shortly thereafter, and then hiring a translator to transcribe those documents into English. But I've still not received those documents. So I'm going to make a pitch for 6 weeks if the court will grant it.
All right, Miss Rakek, what is your response?
That is totally fine. With me and Samuel, we are talking and stuff, but that's totally fine that we set it over for 6 weeks.
All right. So hearing no objection, July 30th would be 6 weeks exactly. Does that work for the parties?
Whatever works for Miss Bliss is fine with me. In the courts, I pretty much open.
Okay.
Your Honor, can we go 1 week further? I'm scheduled to be out of the office that week. So August 6th.
Does that work for you?
Or a week prior, if that's too far out, that's fine.
Would it? August is our camping trip.
Okay.
And stuff, and so
We could.
it doesn't matter to me, but we go around August. I'm not sure what time frame
Okay.
and stuff. So if we could, if it's okay with Ms. Bliss, you know,
We could do July 23rd, or we could go out a little further towards the end of August. So
could we please do that?
the end of August?
I think that'll give a sufficient amount of time for her to be able to get a translator to transcribe those, because some of it is complicated, and I understand that and stuff. So they may run into some hiccups.
Is August 27th available for everyone?
That works for me.
That'd be fine.
All right, so we will set this matter over then to August 27th, 2024 at 9:00 a.m. Obviously, if information is found out prior to then and you want to move that date up, you can always request that. Sounds like everyone is in communication and good contact. So, but at this point, we'll set it to August 27th, 2024 at 9 a.m.
Very good. Thank you, Judge.
Thank you.
Thank you so
Bingham
much.
on the video. Is she present in the courtroom?
No, I'm looking, I do have a bunch of people, but there's a lot of people that say observer and guest in the waiting room. And we're, to be frank, very hesitant to let some of those folks in because of our problems with people streaming everything on YouTube. And I'm not seeing, is her last name still Bingham?
As far as I know.
Okay, I'm not seeing any name Tanya or Bingham in the waiting room.
I had previously served and obviously filed our motion for today. We have provided proof in the court file of serving her by mail and by email. It's not uncommon for her to not participate. I did review through Odyssey, and I didn't see any filings submitted by her since filing our motion. The current contempt review order entered on, I believe by your honor, back on February 14th of 2023, ordered a $100 per day sanction for to compel Ms. Bingham's compliance on revealing her employer and employer address with verifiable proof. And this is a longstanding issue of her avoiding her child support obligations, as well as other financial obligations. So at this point, there's no evidence that she has complied. My client has not received documentation relative to the identity of her employer's address. She's currently under the Washington Confidential Address Program. And we even went so far as to file a motion to release her confidential information form so that we could see if she had completed that form by disclosing her employer. And unfortunately, she had not. So at this point, we're asking the court to enter the order that I've provided to your honor. We're also asking for the court to reduce to judgment the interest that has accumulated on prior judgments that have been entered in this court. And finally, we're asking for an additional contribution towards my client's attorney's fees in the amount of $2,000.
All right, I did review your order. I reviewed the previous orders that were entered. It looks like Commissioner Nelson entered an order with contempt sanctions that have interests. There was another contempt order signed, I think, in April of 2023. And then this is essentially the first time you've addressed it this year. Is started in May of 2024. Reviewing everything, I will sign off on this order. And their court does not have any response either that's been filed.
Okay, and I'll make sure to provide Ms. Bingham with a conform copy once it's available on Odyssey. Thank you.
Thank you. We're on for a motion that was filed by the petitioner, Ms. Krebling, in this case, to remove the GAL. And it looks like the request is to assign a new GAL and revoke any and all changes granted, made by, or influenced by the GAL. This is your motion, Ms. Krebling. Do you have any additional comments you'd like to make?
That I just would like the court to really take into consideration all of the fact findings that I had submitted to the court and to make the best decision.
And you received communication back from the GAL committee after you filed your grievance. Is that correct?
That is correct.
Okay. All right, Mr. Zandy.
Yeah, just really briefly, Your Honor, I think this is one of those cases where you've got a party who doesn't agree with the GAL, doesn't agree with the court orders, and is essentially asking for a do-over. And again, that's what trials have. It's not uncommon for GALs, for the court commissioners, for the judges, for everybody alike to make recommendations or rulings that one party or sometimes both parties don't necessarily agree with. That's why we have this system in place. That's why we have each party's right to go to trial and present whatever information they want to. Fortunate, in this case, we have a trial set for September, and hopefully that gets out and can be heard. This child needs some finality to this case. This is one that, ironically, you're on the bench today, Your Honor. You've heard the majority of the hearings in this case going back to last summer. Would point out that Ms. Krebling has always been represented by counsel until relatively recently. At that time, the parties agreed to adequate cause. This is the case where there was significant information about the struggles of this 12-year-old child at that time, Mason. Your Honor heard the majority of those hearings. Parties agreed and stipulated that Ms. Height would be a suitable and probably the best GAL for this case, given the circumstances and the allegations. Court agreed with that. Ms. Height was appointed, again, over no objection of either counsel at that point, me included. Conducted not only one investigation, but multiple. She's issued supplemental reports. She's been timely. And I believe it was Your Honor who, again, commended for the work that was done and that it was a thorough job and that it was timely, and court appreciated that, as did the parties. Custody was transferred last fall. The child, again, I was somewhat surprised to see Ms. Krebling's comments just is not borne out by the information. Mason is doing very well. doing very well at school in Woodland, doing very well with his father. Times have adjusted, and I can confidently say, and again, I'll reiterate this point at the trial, hopefully in September, court made the right decision on this. So simply because one party does not agree with the recommendation is certainly not a basis to pretend like that doesn't exist. I think the standard is extremely high when it comes to GALs, the conflicts, which none was presented and no allegations were made related to that and such. And here we just have a party who's essentially asking to do over to extend matters. These parties have gone to mediation. That's been unsuccessful. My client gives you kind of his synopsis of what happened at mediation. And unfortunately, that was a large waste of time. Again, given many of the similar attitudes from Ms. Krevling that we now see contained in this motion. I would certainly ask that the court deny this. I don't think this is timely. I don't think it's proper. I certainly don't think it conforms with the rules. As it's 7 pages of single space, small font with significant exhibits and affidavits attached. And again, I think the timing of this is peculiar. Now, we are now on the eve of trial, which is 2.5 months away. And at no point prior to this, so that was when Ms. Krevling was represented by counsel. This is when we had the hearing after hearing back in the fall. At no time did anybody raise any questions about the insufficiency of Ms. Height's report and investigation. So to have this motion now brought in the early summer of 2024, knowing that there's a trial in 2.5 months, again, seems suspicious. I would submit, and my client has detailed this in his response, that this does seem rather frivolous. This does seem like, again, something that's not supported by the facts or the law. My client is requesting an award of fees and costs in this. These parties attended mediation separately and on their own, again, to save on these costs and hopes, from my client's perspective at least, that some resolution could be made. Unfortunately, that wasn't. Cost is certainly of concern to my client. We are asking for some contribution in fees and costs for responding to this, which again seems quite frivolous under the statute, under the case law.
Right, thank you. And I've been calling you Miss Krevling, but it looks like you now go by Hearn. Is that correct?
That is correct.
All right, I apologize. So any final comments, Ms. Hearn?
I do. The school never, just kind of going off of what Mr. Haugen had said in his thing or in his declaration, the school never indicated whether it was me or dad that it just indicated that there was outside factors that were influencing Mason's distress or so-called distress. The mediation was supposed to be confidential and not mentioned. Therefore, I request that it all be redacted from the declaration. If I was not acting in good faith, then the mediation center would have let the courts know that I was not, in fact, acting in good faith, which, to my knowledge, that has never happened. It is my understanding that the GAL is supposed to act in the best interest of the child. It is my understanding that the GAL is supposed to contact every individual that is or was brought up to help provide facts, which she never did with Mason's coach. Mason's coach was a witness firsthand to a major incident of Garrett's or Mr. Haugen's religious behavior, and she failed to do so. She failed to reach out to, sorry, hold on one second. Can I shut my dogs up, please? They're playing. Oh,
I can't hear them if it's bothering you.
Okay, somebody else did it. And there is several incidences where Anne did not follow through with her duties of a GAL, as I had mentioned in my declaration, and I provided facts stating so. Mason is not as good as what Mr. Zandy is trying to portray. In fact, I have shown multiple times, and there has been a recent one as well that I was not able to submit because this was already submitted prior, where Mason is struggling. Mason is going and seeing the
getting very far afield of what the basis of this motion is for. I'm just object to nothing that goes afield of any of the information contained in the overlay declaration already submitted.
No, this is in my declaration. This isn't over. This is in my declaration.
Your declaration was, well, massive. It's 72 pages, filed pages, which I don't know if that necessarily complies with the rules, but it sounds like you're concerned about more recent issues that your son is having. Is that fair?
Recent issues and past issues. It is massive because there is a lot of different things that Anne did not complete, that Anne did not do her job on, or job properly on. She did not, like I had mentioned, she did not follow through and contact every individual that I provided to her. She pick and chose what she wanted to do, who she wanted to contact. She picked and chose what she wanted to add, regardless if it was factual or not. Like I had mentioned, the school indicated that there was outside conflicts, but never mentioned whether it was mom or dad or whether it was either one of us. But Anne had put in there that it was mom. She spoke with a counselor at the school that never even spoke with our child. Never spoke with our child. He was a new counselor to our child that was only his counselor, the school counselor, for a month. She based a lot of her opinion on that school counselor. Mason has religiously been in a sport his entire life, just about. He loves soccer. Immediately, Mr. Haugen pulled him out of his sport. Immediately. And I warned Anne that this was going to happen. I warned Anne that our son was going through a very dangerous path. He is now fully against the LGBTQ plus community.
We are so far afield of the basis of this motion as this is issues for trial, not to disqualify GAO.
No, I'm trying to point the proof that Anne did not follow through with her job properly, that she did not put the best interest in the child, that she was completely off of what her duties as a GAL is. I understand that my declaration was 7 pages. I understand that there was 72 pages that were submitted. And that's all proof. There is, like I said, 7 pages of things that the GAL did not do or did not do proper. And I fully believe that she did not act in the best interest of the child. Mr. Haugen was court ordered to complete DV classes, AA classes, parenting classes, and there's another one on it right now. It's in my declaration. But yet Anne still gave custody to the individual that is supposed to complete these classes that never completed these classes. Never. He has had years to complete these classes and he has never completed these classes. I brought up to Anne, well, hey, Mason is very aggressive when he comes back from his dad's house, and he will then straighten back out. He'll become my loving child again. And then when he goes back to his dad's house, it does this all over again. He is very aggressive. And I fully believe it's because his father is imprinting these things in his head. For somehow, I was also the one that was pointed at, that I was the one that was giving Mason, our child, poor information. That is untrue. Somehow Mason knew about this court today. Somehow Mason knows that I am telling Anne, or that I told Anne, pertinent information that a child should never have known. Mr. Haugen is the one that is telling our child these issues with court. Mason comes to me almost every time.
Okay, I'm gonna cut you off there. Ms. Hearn, we're getting into what you would present at a trial. Clearly, you believe that Ms. Height didn't do her job effectively, that she didn't interview every single person that you gave her to interview. I would disagree that that is her job. I'm not saying that she should selectively pick and choose, but she is a neutral party, and the court feels that she is a neutral party and is just a fact finder looking for the best interest of the child. The decision was made to switch custody several months ago. That's still where we're at in this case. Trial is currently set for September 9th, 2024, or the week of September 9th, 2024. Your opportunity to present that contrary evidence is at that trial by the subpoenaing of those witnesses that you feel would make those points that you feel that Ms. Height did not make. At this point, I'm not, Ms. Height isn't, as far as I know, doing any additional information gathering. I'm not going to remove her as a GAL. She is allowed to be called as a witness. And I'm not going to assign a new GAL at this point in time, given how close we are to trial. I'm not going to revoke any and all changes granted, made, or influenced by the GAL immediately, so I'm going to deny your motion. However, these issues can be determined at the time of trial, which is currently set for, again, September 9th, the week of 2024.
And can we reserve on fees for that time, Judge?
Fees will be reserved for trial, yes. And I'll include that in this motion, denial.
Are you drafting a bench order to that effect so we don't have to come back for a presentation?
I am actually adding it into the removal of GAL order that Ms. Hearn presented, just indicating that her motion is denied. The issues will be determined at trial, which is set for September 9th, 2024, and any fees would be reserved for trial.
Very well, thank you.
One last thing, Your Honor, if I may. In part of my motion was to have Anne investigated. Can we please have Anne, the GAL, investigated on these accusations?
That's what the GAL committee did. And my understanding is they reviewed your complaints. They went through the process that they have to go through. I'm not on that committee anymore. And my understanding is that they didn't find any concern with her investigation in this case. And it was sent back to the trial judge or the docket judge.
The document that I had received was because it was sent to trial or here because it was an active case and they don't do anything with active cases. And so it's my understanding that it's the judge that has to grant the investigation during trial, or else I have to do the investigation after everything is finalized.
All right, I'll have to talk to the GAL committee. I don't have what they sent you. I'm aware of what the process is supposed to be. So
okay.
Unfortunately, I don't have that letter or what it says in front of me, and I don't know. Ms. Height, I'm assuming you received a copy of that letter.
Yes.
I don't know if you have it or know what it says, and I'm not suggesting Ms. Hearn is incorrect. I just.
I did receive a letter. It was very brief, just saying that nothing was going to happen at the present time. It was a copy of the letter to her. It wasn't a letter to me personally.
All right. What I'll do, Ms. Hearn, is I'll take that. If a determination needs to be made by the docket judge whether an investigation takes place, I will review that and take that under advisement and make a ruling on that if that's needed And if it is not needed, then we'll make sure to get notice to you that that isn't the process. But I will need to review the GAL guidelines and policies and procedures because I don't have them memorized, and see what the letter sent out was. But if there's something that needs to be done to trigger an investigation, I'll review everything and determine whether that's appropriate at this point, and then let you know the outcome. Is that fair?
Okay. Yes, thank you so much.
All right, thank you all. 08.
Thank you, Your Honor.
Good morning, Your Honor. Jennifer Joslin for Sarah Williams, who is present via Zoom.
Right, and we have, I believe, Dustin Williams is present. And it looks like we're on for a temporary order. And there was
Yes.
a temporary order that had phases it was entered back in June of 2023. Mr. Williams is wanting to move up in his phase. And I guess Miss Williams is concerned that there's still issues, and that's kind of where we're at. So I believe this was Mr. Williams's motion.
Yes, Your Honor. Before we begin, just for clarity, the phases haven't actually been ordered. The only thing that was ordered was reunification counseling. The actual phases are not a court order. And we just wanted to inquire if the court received and read the counselor's letter. If not, I think it would be in everyone's best interest to set it over, as that's quite lengthy and informative.
When was it filed?
It was, I just got it back Sunday, so it was filed Monday and served, and we sent it down with a second set of bench copies.
Okay, then no, I have not reviewed that.
Okay, then we would ask for a set over so the court can review that, as that is the child's personal therapist who has seen the child since the abuse by Mr. Williams. I also believe Mr. Williams filed a sealed source document late as well on Thursday that we did not receive until Friday. So in that light, we would ask to set it over 2 weeks so the court can review that, because the letter is quite lengthy and very indicative of her thoughts in the process.
The last thing I have in the court file is an affidavit of service from you, Miss Joslin, regarding
Probably proof of service of our response.
proof of service, and it was from the, looks like yesterday when I reviewed the file yesterday. The last thing that was noted, I always mark that because it tends to change, was the confirmation and proof of service from 6/14. So there appears to be a new filing that is here that wasn't there when I reviewed everything yesterday. And it looks like it's a letter from Desiree Mansour.
Yes, Your Honor, and I think that's very vital to the next steps. I mean, I'm happy to read the integral parts into the record, but I know Your Honor likes to diligently review everything before her.
Mr. Williams, have you received a copy of that Ms. Mansour's letter to the court that looks like it was dated June 14th?
Yes, Your Honor.
All right. I haven't had an opportunity to review that. I guess, what is your position on setting this matter over 2 weeks?
I don't want to set it over, Your Honor. It's Barbara Brandhorst, our reunification counselor. She's made it clear several times that Miss Mansour's never met me. Like, she's just writing her reports off of what Sarah says. So, and what Barbara has, for the last year, she's witnessed several interactions with my son and I. She doesn't see what Miss Mansour says. Like, so Barbara's professional state approved opinion is just way different than what Miss Mansour has to say. So I don't want to set it over. I don't want to go any more weeks. We just want to try to move forward. I've done as everything that I've been asked to do to try to move forward. That's why we're at this point right now, because Sarah and Jennifer didn't have an intentions of going into phase 3. We all agreed on this phase plan that Barbara, the reunification counselor, put forward, so that we could just kind of move forward. And Sarah wrote the reunification phase plan with Barbara. So Sarah, Barbara, and Jennifer all made that phase plan that we all followed. And then
Your
all of a
Honor,
sudden,
we're gonna object. I did not write a phase plan and my client did not write a phase plan. So I'm not sure where this is coming from, but we were not involved in writing any plan.
If you're wanting the court to enforce a phase plan that the court didn't initially order, then that's also kind of a problem, Mr. Williams. Because I don't have a phase, if there's no phase plan in the temporary family law order from June of 2023, then how am I supposed to enforce something that I don't, A, know what it is, B, there's no authority for me to enforce since it's not been ordered by the court previously. So I guess, and I reviewed everything that's been filed in 2024 in preparation for the state, but for the letter from Ms. Mansour, and I didn't see anything. There was no phase plan that was filed with the court. There was nothing. The temporary order indicates the parties will mutually agree on a reunification therapist. It talks about the who pays how much. That the reunification therapist will work with Ms. Mansour regarding the child's progress through this process.
that's why, Your Honor, sorry, that's why I filed this motion to modify everything, because I want to follow the recommendations of Barbara Brandhurst's recommendations. And just make sure that we have it, court ordered. We all tried to avoid coming to court and just tying up the court's time and stuff. So that's why we all agreed on it. Sarah's been giving me more time. So I just don't understand why we can't, have this modified, have it set in stone by you so that we can. I just don't want to set it over. We've waited so long. It's been
I appreciate that. This isn't it's a couple different things. So Mr. Williams, and you're kind of, it's just bad timing a little bit. This is not my regular docket. I'm covering this docket for another judicial officer. I was told yesterday I was covering this docket. I reviewed everything I possibly could. It did not include some of the responses to your motion. I think it's appropriate for those to be reviewed before your motion is heard, especially given who this response is for. And the only order that I have that's from June of 2023 indicates this person is someone that the court has deemed appropriate to determine the child's progress and well-being through this process. So I think it's important that Ms. Mansour's information is reviewed by the court, since that's one of the individuals that the court back in June of 2023 indicated should be involved in this process. So I'm going to grant the request for a continuance. I'm only going to give it 2 weeks. So it'll set over to July 2nd, 2024 at 9:00 a.m. And the judicial officer, since everything is now filed, should have the opportunity to review everything and be ready to make a determination on that date.
And Your Honor, is it possible that we could set it out just one more week? My client's on a camping trip that week and she'll be out of area. She'll have no Zoom capability.
I'm giving the request for a continuance, and I'm going to July 2nd.
Okay, thank you.
Thank you. On for a request to enforce the final decree.
Your Honor.
Yes, Judge, and this is my client's motion, Carly Bliss, on behalf of Lacey Jacobs, the petitioner and moving party for this motion. Your Honor's likely read all of the materials provided for today, so I'll just kind of summarize our requests for the court today. As you are aware, the final decree in this matter was filed in March of 2021. In June of 2021, my client did sign a satisfaction of judgment, releasing Mr.'s obligation, at least on paper, for that $80,000 judgment contained in the divorce decree. You've been provided substantial text message documentation documentation over the last 3 years between these parties, which confirms my client's position that even though the satisfaction of judgment was filed, it was never actually satisfied. And the agreement between the parties was that the monies were still going to be forthcoming. My client provides for the court all of those text messages in her responsive declaration and in her initial declaration with her motion, indicating it was her understanding based on the agreement of the parties that Mr. was unable to qualify to refinance the home out of my client's name after the divorce with that $80,000 judgment, essentially clouding his debt to income ratio. You've seen text messages between the parties indicating he couldn't refinance. Even his own declaration, excuse me, he confirmed that he was having difficulties refinancing the home into his own name. My client, clearly frustrated with the process, she acknowledges for the court she was frustrated that it was taking so long, frustrated that her credit was hamstringed and tied down to this house that was awarded to Mr. by agreement when the parties finalized their divorce, that she had wanted the children of these parties to remain in a stable household as long as she could. She wasn't trying to essentially make Mr. and the children, when they were with him, homeless. So she's been more than reasonable, provided more than sufficient timing in order to allow Mr. to refinance the home. He did refinance the home, and then we still wait 2 years at that point for any sort of payment, any sort of movement towards selling the home. She provides for you that in October of 2023, he did eventually sell the home, earning substantial profit. In February, she received 3 $10,000 payments directly to her bank account and was told more would be forthcoming. Then, obviously, my client assumes after meeting with counsel, he indicates, nope, satisfaction of judgment was filed back in June. I'm under no obligation to pay you any funds. Again, this is contrary to the text messages over the parties between the last 3 years, contrary to the fact that he did make 3 $10,000 payments. And then simultaneously in his declaration, he asks the court to essentially applaud him for generosity for paying 3 $10,000 payments when he had no obligation to do so. His declaration is frankly perjury, and that is contradicted by the text messages of himself between him and my client. The satisfaction has not been, or the judgment, excuse me, has not been satisfied, and that is clear by the parties. In Mr.'s responsive declaration, he indicates, oh, we essentially had a de facto timeline of when I would pay her. Again, acknowledging the fact that there were still monies outstanding. So now to claim I don't have any obligation to her because she signed that satisfaction. I was generous in paying her $30,000 and I don't owe her anymore, is frankly inappropriate. You have before you the final decree. Pursuant to that decree, Mr. was awarded the lion's share of the community property. Granted, he did take a substantial period, a portion of the party's debts, but again, my client's credit was bogged down for over 3 years, and she was unable to essentially move on with her life, which is what the whole purpose of the divorce is, and the whole purpose of equalization between the parties at the time of the divorce. The court, had this gone to trial, is tasked with making sure that the parties are dividing their assets and debts equitably. To now say Mr. owes my client nothing would be inequitable. He would be reaping the benefits of having the lion's share of the community property and having no obligation to my client. My client would be leaving the marriage empty-handed, absent this $30,000 that was so generously provided to her by Mr. Jacobs. So at this point, we are asking the court to honor the initial divorce decree, requiring Mr. to pay the remaining $50,000. We are also asking for the interest. This has taken over 3 years in order to get these funds. Alternatively, my client points to Section 2 of the divorce decree, which ordered Mr. to refinance the home within 30 days. He even acknowledges he failed to do that. Pursuant to the decree, he was then required to put the house on the market and immediately sell it, and the parties were to split the proceeds. That is what the parties agreed was equitable. That's what the parties agreed was fair at the time of the divorce decree. So we are asking for the relief as cited in our motion. We're also asking for a substantial contribution to attorney's fees. Again, Mr. has acted in completely bad faith. Even after retaining counsel, this matter has been prolonged several months, attempting to resolve the matter without litigation, only to be forced to file this motion, and now being essentially slapped with the same request by Mr. of, oh, this motion wasn't necessary, I had to incur fees. He did have to incur fees because he was being unreasonable and acting in bad faith. So we are asking for the request cited in our motion, and that's that. Thanks, Judge.
Thank you. Mr. Flake.
Thank you, Your Honor. And I'll keep this short and sweet too. I know that we have a lot of materials to go through. So, Your Honor, the satisfaction of judgment filed on June 2021 says that the judgment has been fully satisfied. Therefore, a full satisfaction of judgment is hereby acknowledged, and the clerk of the court is hereby authorized to direct, cancel, fully satisfy, and discharge the judgment. So, understandably, the opposing party is having issues that she feels they're not being addressed by the final order and filed a motion for enforcing final order. However, she also entered satisfaction of judgment that verbatim says that this order has been satisfied. My client understands and has been obviously paying to the opposing party. We're acknowledging that that's happening. However, this is a gray area that I don't think can be simply just determined today just on a motion to enforce basis. I think opposing party can't say that my client acted in bad faith when she then filed the satisfaction of judgment, and then they have this discussion of making payments on top of that. It is much more complicated than simply just saying, okay, this is what the original agreement was, and so we need to go back to. I don't think it would be reasonable of the court to make such a hasty judgment based just on text messages as well, when we have two actual binding documents signed by both parties. Well, one actually just by the other party for the satisfaction of judgment. My client has acknowledged that there was a need for this. Obviously, the June 9th text, the other party just told him to get it done basically with a little more explicit of terms. But the reality is this has just been done improperly. If this was what the issue she had, I don't see procedurally how we could have done anything else but respond the way that we did. There was a satisfaction judgment that said that the final decree was completed and satisfied. So at this point, if the other party wanted to do something, I think there needed to be a different way to do it. And I'm glad it's before the court today to make a determination on that. But I think opposing counsel and opposing party's position oversimplifies the issue. If she wanted this done properly, she should have not filed a satisfaction of judgment and acknowledged that the final order was satisfied. I think it's pretty simple. So, we are asking for attorney's fees. I don't know if this is even the right, method or channel for opposing party to be going to get this dealt with, because how are we enforcing an order that's already had a satisfaction of judgment filed? So at this point, I leave it to the court's discretion. I think that our request for attorney's fees is reasonable because, frankly, I don't know what was proper here, but I don't think a motion to enforce is proper when the satisfaction of judgment was entered, 3 years ago at this point. So thank you, Your Honor.
Ms. Bliss, anything else?
Just briefly, Your Honor, and my client's position is that the satisfaction of judgment being filed to allow Mr. the ability to refinance, which he doesn't deny. He was incapable of refinancing until the satisfaction was entered. It was an agreement between the parties that the satisfaction would be entered to allow him to refinance. And that's clear based on the timeline, based on the text messages provided for you. It's our position that the satisfaction of judgment being filed to allow him to do that refinance is an akin to a quitclaim deed between parties who are married buying a home. It's not relinquishing their interest or their rights to the property or to the assets as we are here. It's essentially trying to do it for ease for the people that be the refinancing company or the title companies and homes and things of that nature. So I don't think that my client signing that is relinquishing her rights to the funds, and I think that's also documented by the agreement of the parties through text messages. Mr. has not said, nope, I don't owe her anything. It's simply saying, I don't think that this is the proper avenue to do so. And I would challenge, I don't believe that there's another avenue to do so, but to enforce the divorce decree. That was the agreement between the parties, and that's severely documented by text messages. Again, in reference to the June 9th text message where my client throws her hands in the air and says, just take the home. Again, Mr. provides a very small snapshot of the entirety of that conversation, which my client has provided the full text message thread in her reply documents to the court. Again, she admits that it was in a moment of frustration, but as you can see throughout the remainder of those text messages, it was not her saying, nope, don't want anything from the home, just take it. It was, I'm frustrated. What do we need to do to get the result that we're both wanting? And that's exactly what they did. They signed the satisfaction of judgment. He was able to refinance. You saw in the text messages, he said, as soon as I refinance, I'm going to have to take a HELOC on the home in order to pay you your funds. Why would someone who's satisfied their judgment and doesn't owe anything to my client continue to make those conversations? It's very clear what the intentions of the parties are. It's not oversimplifying it. We are asking for the relief that we've requested, and we do believe that we're entitled to do so.
All right, here's my position. The one concern that I do have, we do have the satisfaction judgment. Wouldn't we need a motion to set aside the satisfaction of judgment and then enforce the decree? And I guess, so in one sense, I agree with Mr. Flay that this is improper. I would indicate that Mr. Jacobs, I think, is being very disingenuous to the court in how he's relayed his his version of events here. It's very clear to the court that Ms. Jacobs did what she did in order to assist Mr. Jacobs in getting really what he wanted and to get her portion of the money out. I think as we sit here, Mr. Jacobs owes Ms. Jacobs $50,000. To me, that seems very, very obvious. Legally speaking, and I don't know the answer to this. That's why I'm asking. I don't, and this is to Mr. Flay's point. Do we need it? Does that satisfaction of judgment need to be addressed or moved to be set aside before we can move to enforcing the underlying decree? And I would also note, just for the record, in case it wasn't clear, I think it's important to note a couple different things from this final divorce decree, that neither the refinancing, that did not happen within 30 days. That's very clear. And the home was then not put on the market for sale after that 30 days. So Mr. Jacobs clearly gave a middle finger to that divorce decree. Whether there was some agreements between the parties beyond that, clearly they seemed that Ms. Jacobs was trying to work with Mr. Jacobs, and only for him to turn around and not own up to his end of the bargain. I just have a concern about whether we need to address the fact that there is a satisfaction, a judgment filed in this case before we do anything else. So I guess I'd ask the parties to respond there.
Do you want to hear from me first, Your Honor?
Sure.
Okay. Well, and Your Honor, that's our position. Is procedurally, as I acknowledged, I don't think it's proper to be able to move forward. I mean, the record wouldn't be clear. And I understand opposing counsel's position. I mean, I know she was acting in good faith to file that motion. There's nothing against that decision, but I just don't think that the superseding document at this point is a satisfaction judgment in the record, plain and simple. So I think if there were to be a next step for determining this, I think we do need to do something, either a motion to vacate or something to that effect, which wasn't patently apparent to me at the time going through this. Obviously, it's easy to get tunnel vision when you're reviewing everything. But that would be our position, is that something needs to clean the record up before moving forward with this motion.
And I guess my position, Judge, and unless counsel is willing to stipulate to the vacation of the order, which I don't imagine is the case today, I think the timeline is already lapsed on a CR 60 motion, which I think is the only remedy my client would have.
Is this your client, Mr. Jacobs, here? You can take your hat off, sir, because we're in court. We are talking about your case right now, and sorry, go ahead, Ms. Bliss.
And Judge, just I don't believe, and I mean, I can look into this further if Your Honor wants to essentially put a pause on the hearing, and counsel and I can provide briefing. I don't know what his position is, but I don't imagine he would agree to a vacation of the satisfaction. So if my client were to bring forth some sort of motion to vacate, I think her only real remedy would be under CR 60, which does have the timeline of a year. So she would then be barred from bringing that unless there's another avenue that we can go, which off the top of my head, I don't have that information before me right now. So I guess we are kind of at a stalemate or a current issue.
Well, I'm going to reiterate the court's position since we do have Mr. Jacobs present now. I think that it is wholly inappropriate, and he's being very disingenuous to the court by indicating that he doesn't owe Ms. Jacobs anything. It does seem very obvious to me that Ms. Jacobs did what she did to assist Mr. Jacobs in his acquiring or refinancing of the home. And then only to turn around and frankly not pay her what was owed. We can argue about whether it was appropriate to enter that satisfaction of judgment, but that was done in the court's purview by the records that were submitted, text messages. Ms. Jacobs did that at the request of Mr. Jacobs so he could do what he was court ordered to do, albeit several months after he was court ordered to do it. And then didn't put it up for sale as required under the final decree. He didn't do anything that he was supposed to do. So we're here now. I would like the parties to look into this a little bit further. Barring anything that tells me that I can't, I would be willing to grant the request of Ms. Jacobs in this case. But I do have, I guess, some concern that there is that satisfaction of judgment. And so that's where I'm at. I don't want to rule in favor of Miss Jacobs, and only to have that be, I guess I'm not worried about being overturned, but I obviously want to make the right decision from the beginning. And that's something that I feel like I need more information about. So if the parties want to brief that, we can set this over 2 weeks, 3 weeks, and the court will be happy to reconsider.
Understood, Your Honor. 3 weeks would be preferable. I'm actually, I'm changing firms and taking some time off. So 3 weeks would be much more easier for us to manage in that transition time.
Would we be putting it on your Friday presentation, or is this going on a normal Tuesday docket?
I was going to put it back on the 9th in front of Judge Hahn. And if she feels and you all feel it would be better to be back in front of me, we can put it on a Friday.
I would almost prefer, just given Your Honor already hearing today, already partially making a tentative ruling, essentially, if we could be back in front of you. I just think for judicial economy, it makes more sense instead of re-arguing the case for Judge Hahn and then having her make, unless, I don't know, counsel, do you have a different position?
I think that's reasonable. Counsel.
I have Friday the 28th of June, so like a week from this Friday. And then I wouldn't have a Friday until the till the 26th of July.
We're fine with the 26th. As I said, I'm going through a transition period. So
Friday the 28th?
Or 26th of July. I'm in mediation on the 28th.
Mm-hmm.
Oh, you're asking for the 26th of July, Ms. Bliss. What is your, does that
I know my client's not going to be satisfied because she wants it done sooner rather than later. But I think given Your Honor's calendar, I don't think we really have a choice. So the 26th of July is fine.
Okay, so we'll set this on to the presentation docket for July 26, 2024 at 8:45 a.m. That'll be in front of me. Any briefing you can address, any bench copies or whatever, please address to me so I get them and I can review everything before that hearing.
Very good. Thank you, Judge.
Thank you.
Thank you, Your Honor. Thank you, counsel.
Yes, Your Honor. Noelle McLean appearing on behalf of the respondent, Tucker Sandana.
All right, and it looks like, and we have Ashley Swindell present.
Yeah, I'm present, Your Honor.
All right, thank you very much. Every once in a while I review my notes and they don't make sense to me, and so I just have to look at something before, and then it all usually comes back. So just give me 1 second. So it looks like there is a motion. The contempt motion isn't on today. Today is the motion for temporary family law order, correct?
Yes.
And that was filed by Ms. Swindell, and it looks like there is a new proposed parenting plan being requested for those 3 children. And right, and I reviewed, for the record, I've reviewed that motion, the declaration support, the proposed parenting plan, and then the reply declaration. And let me just, the reply declaration. I'm weeding through here to make sure that I'm not conflating the contempt motions with or contempt responses with the responses to the parenting plan. So Ms. Swindell, go ahead. It is your motion.
Thank you, Your Honor. First, I wanted to emphasize to the court that I have been the primary parent for all of the children up until March 19th, the last court date, and that Mr. Sandana had no issues with our children being around me, my partner, or my partner's child until I filed for full custody of Jackson, which would have required him to pay child support. The sudden shift in this stance shows his intentions are financially motivated rather than focused on the children's well-being. Despite having the ability for years, Mr. Sandana has never put our children on medical insurance. They have only had state medical coverage or the medical insurance provided by me through my work.
I guess I'm going to object at this point, as this exceeds the documentation that I received. And I note at the top of this motion, Your Honor indicated you reviewed a declaration. I've not received a declaration for this motion. I received a motion for temporary orders, and information regarding a temporary parenting plan, a proposed parenting plan. And then subsequently, we had received a proposed temporary family law order, child support worksheets, child support order, and the docket notice and a summons to modify the child support.
Okay, I didn't receive any of the child support information, so I don't have that, and I don't see that as part of her initial motion. So I don't have any of that before me. So child support is not something that will be discussed today. And I will clarify, in Odyssey, it is listed as Index 53. It says declaration in support of a parenting plan. When you look at that, that's the information for a temporary parenting plan. So I don't know if that was entered incorrectly or because it's not a declaration. As we think of declaration, it is the information for a temporary parenting plan.
Right. So given that, I would object to the argument that exceeds the scope of her declaration.
And I'll sustain that. So Ms. Swindell, you need to keep your argument to the information that's been provided to the court and the other party.
Yes, Your Honor. Yes, Your Honor. Okay. So our oldest son has been grounded for over 2 months, which I believe I've put in the letter that I've given to the court and to Ms. Noel. He's been grounded for communicating with me about issues that are going on in the house. My middle son, Ray.
I'm sorry, but again, I'm going to object because this is new information that should have been included in her initial declaration so that my client could have had an opportunity to respond. I saw that documentation that was filed this last week as being responsive to the pending contempt motion.
I don't see, Ms. Swindell, anything in your motion for temporary order or your declaration in support of a parenting plan that indicates that anybody has been grounded for 2 months for talking to you. I understand that you're alleging that there's parental alienation. So I understand that, and I don't know if that's
partly due to the.
All right, go ahead.
The alienation that I'm referring to is part of the lack of communication that he's been imposing on our children. If they communicate with me about anything that's going on in the house, he will remove their cell phones from them and tell them that they're inappropriate for contacting me about issues. And it's been going on now for 2 months with our oldest.
Again, I would object at this point due to the hearsay.
All right. Here's my concern. There's a couple of different things that I'm just going to put out here right now. So the parenting plan, the last court date was in mid to late March, where Judge Hahn entered an order appointing a guardian ad litem. She entered a temporary family law order, a child support worksheet, and a temporary parenting plan. Does everybody agree about that?
Yes.
And that temporary parenting plan was, I'm looking at it right now, has Judge Hahn's lining out a whole bunch of different areas, striking certain areas, reserving on certain areas, and clearly Judge Hahn made the determination on this temporary parenting plan. We can all agree on that, I believe. I understand that there's a motion. This is a little bit unusual for within 2 months to have a motion for a new parenting plan entered. There wasn't a motion for reconsideration of Judge Hahn's ruling. But if you're asking for a completely different parenting plan than the one that Judge Hahn just entered 2 months ago, I think it's most appropriate to be heard by Judge Hahn, since there's clearly a reason why she entered the parenting plan that she previously entered. And I will tell all the parties that I did not, and I know that there's a GAL on board now, so that could be additionally helpful, but I did not review anything prior to that temporary parenting plan being in place. So I don't have any background as to why that order was entered the way that it was ordered. So clearly, Ms. Swindell, you have some concerns with that. I can understand that and sympathize with that. I'm assuming you've been working with the GAL since they were appointed 2 months ago. Is that correct?
Yes, Your Honor.
All right. What I'm inclined to do, and I don't know if the parties are available on either July 2nd or July 9th, but I think this is most appropriately heard by Judge Hahn, since she literally just entered a temporary parenting plan in this case.
Your Honor, the contempt motion is scheduled to be heard on July 2. So for judicial,
Is everyone available on July 2nd?
yes.
Yes, Your Honor.
All right. So I'm going to set this over 2 weeks to July 2nd, 2024 at 9:00 a.m. for Judge Hahn to hear the merits of the request for a new parenting plan.
Thank you.
So everything at this point will remain as is, and we'll come back in 2 weeks and you can make your arguments before Judge Hahn.
All right, thank you.
Thank you. And this is on for temporary orders. Right.
Yes, Your Honor, Noel McLean appearing on behalf of the respondent, Alexis Doble.
Chance Fuel with respondent, Your Honor.
All right. Good morning, everyone. This is a new case. I did review everything in the file that has been submitted, and I'm ready to hear from the parties.
Your Honor, this comes on my client's motion for temporary orders. We have been in front of Commissioner Warning, Judge Evans, and I think those were the two with regard to the competing protection order and anti-harassment orders. My recollection is that those are good through Monday, and so we're asking for the court to enter temporary orders today, including a restraining order protecting my client and the child. This is a short-term marriage of 2 years. These parties have one child born as issue of their marriage. Harper is currently 8 months old. In addition, my client has an older child, Trinity, who is 10 years old. Trinity does not have a relationship with her biological father, and my client does not receive child support, so she's fully responsible for that child. My client outlines for you in her declarations her role as Harper's primary parent, the period of time that she took off from work in order to establish that bonded relationship with the child. And even during the time that she had suffered from mastitis and septic shock, the child was with her within that hospital. Mr. Brodeur unfortunately suffers from substantial substance abuse and domestic violence issues and has substantial history relative to those. We've provided for you, at least by way of a thumb drive, 3 different videos. I'm not sure if the court had an opportunity or if the court reviewed through those, or if you're in a position where you want me to play those for the court through screen sharing, whatever the court deems is appropriate. But my client outlines for you that the video from August 8th of 2023, she was 7.5 months pregnant with Harper at that point. And that video shows Mr. Doble being intoxicated, coming over to the side of the bed because she was in bed at that time, grabbing her. She tells him to take his hands off of her. He goes to the end of the bed and throws his cell phone at her. The video from October 6th of 2023 again portrays him being intoxicated. Trinity, you can see Trinity coming into the bedroom. Again, my client is in the bedroom with Harper at that point. Mr. Brodeur proceeds to throw his keys from his pocket at my client. And then the day of the party separation on April 14th of this year, again shows him intoxicated in the middle of the day. He prohibits my client initially, blocking her from leaving the residence when she's trying to remove herself and Harper from the residence. He then follows her out to her vehicle. At one point, you see him go to get into his vehicle, and she reminds him that she will call the police on him if he drives intoxicated. She goes to her vehicle, at which time he stands in the doorway so she can't close the door. And it is very concerning relative to what you see on these videos and the corroborating information that my client provides to you compared to Mr. Brodeur's own declarations and the information that he provides to the substance abuse evaluator in this most recent substance abuse that he provides for the court. In the competing protection order hearings, Judge Evans ordered Mr. Brodeur to participate in a urinalysis. And at that time, the court ordered that if his UA showed positive for alcohol, that his visitation would be supervised. In fact, his UA did show positive for both alcohol and marijuana. And what's concerning about that is that he had Harper the weekend before under the protection order. The protection order at that time originally had allowed visitation from Friday to Monday, even though that meant that he would run out of breast milk in the meantime. And subsequently, Judge Evans reduced that to Friday afternoon to Sunday morning to ensure that the child would have enough breast milk, but put that caveat in there that if he tested positive for alcohol, that the court was going to supervise his visitation. And the reason why that's important is because, as my client tells you, Mr. Broder has a significant and substantial history of alcohol abuse. And when he engages in alcohol, his persona changes. And he becomes verbally abusive, where he's calling my client foul names in front of the children. He becomes physically abusive. And she's just provided 2 or 3 different excerpts of those incidents where he's abusive. He attempts to negate away my client's information by saying that he only consumes in social settings. Well, each of those 3 videos do not show social settings. It shows him intoxicated in the household, reacting abusively, verbally, and physically to my client and towards the children. It's also concerning that when you look back to my client's information, she tells you that it was not uncommon for Mr. Broder to consume a 12-pack of beer as well as fortified alcohol in one sitting. The documentation that we've provided from Mr. Broder under sealed health, his Kaiser summary from May 10th of 2023, so a year ago, shows that he at that time was diagnosed with severe alcohol disorder, that he suffers from liver damage as a result of his significant and chronic alcohol consumption, and that he has a history of inpatient treatments, including the Betty Ford Treatment Center. If you look to his self-reported evaluation that he filed with the court on June 6th, you'll see that his stated goal is for moderation. It's not abstinence, it's moderation. And the fact that he's starting out at moderation should be a huge red flag for this court. The evaluation also goes on to state that he does not recognize his significant relapse history. My client tells you that he's not gone longer than a month as far as having sobriety. The evaluation indicated that there were UAs taken, but there is no documentation as to the results of those UAs or whether or not that was even considered by the evaluator. It is important to note that the evaluation submitted by Mr. Broder also says that his treatment will be conducted in Washington State. So that indicates that he was planning on remaining here in Washington State. But subsequently, apparently, he is now relocated down to Oregon. Our position is that the court should give no weight to his current self-reported evaluation. Mr. Broder has previously acknowledged suffering from alcohol or drug-induced blackouts. He's also acknowledged to providers that when he is intoxicated, that he's mean to my client. And our position is that he is now faking good to support his claims to this court. We are asking the court to enter a restraining order protecting my client and the child. Mr. Broder has a history of domestic violence, even with other intimate partners. We provided that documentation attached to my client's initial declaration in support of this motion. What's baffling to me is that if you, and this is within, and I apologize, I should have marked the pages in this. This is in Exhibit B of the attachment, and it's actually 3 pages before, it's Exhibit D. It's 3 pages before the Exhibit E marker, and this is the judgment and sentence from his violation of a protection order, which I think was reduced down to disorderly conduct. You'll note that the court order in that judgment and sentence was that he participate in a DPO assessment for domestic violence conviction and that he participate in a domestic violence assessment. But when you go back to the additional documentation, it appears that they only required, at least as far as probation, they only required an anger management evaluation. So there was a prior court order for him to do domestic violence, and there's a significance there between domestic violence and anger. And we believe that it is appropriate for Mr. Broder to participate in a domestic violence evaluation with collateral input from my client. There should be a new substance abuse evaluation with collateral input from my client. We've also attached to my client's initial declaration a variety of screenshots from the parties' text communications spanning over the 2-year period between February of 2022 and February of 2024, where Mr. Broder acknowledges his alcohol and the negative impact that it's having upon their relationship. So now he's in a defensive position. Obviously, you see that he's filed for this anti-harassment order within the protection order courts. And during the pendency of this action, he and his mother have now made 2 claims to CPS of my client's fitness. She has been investigated now twice. We provided proof of the documentation where she's made a request for the disclosures of CPS records, and it's months before we'll get them, but hopefully whoever's appointed as the guardian ad litem in this case will be able to access those. Obviously, it's concerning to my client that her 10-year-old child was pulled out of class and that now she's being portrayed in a light of somebody who's being investigated by CPS. Obviously, it's concerning to her, but I think that that also speaks volumes to Mr. Broder's sort of scorched earth theory here, that he's going to do everything possible to try and damage the mother of his child to suit his own needs. Contrary to Mr. Broder's statements that he alleges against my client, as she tells you, she stopped drinking, obviously, before she was even pregnant, but she stopped drinking to support him in his sobriety, but he never did stop. He has continued. When he's had even short periods of stopping, he has always had relapses. As part of my client being the primary parent for the child, obviously she's still breastfeeding. Breastfeeding issue was an issue that was raised during the protection orders. My client tells you about her pumping every 2 hours, that she's been able to sustain that without enduring a third case of mastitis. And that Mr. Broder, during the protection order hearing, acknowledged that he was running out of breast milk and he chose to supplement with juice, which is it's not in Harper's best interest and contrary to what doctors recommend at that age. And as a result, she had suffered some significant reaction. The first visit, she ended up in the ER. My client was not advised that the child had been in the ER. She didn't know anything until she was contacted by the daycare provider, who indicated that she was filled with hives head to toe, and was given cream to address those issues. And then my client talks to you about the black stools and the concerns after that. She also talks about the difficulties that Harper has exhibited when she comes back. She comes back exhausted, upset, hungry. She doesn't have a voice, which suggests that she's been crying or screaming for prolonged periods of time. And my client needs to remain as her primary parent, and there needs to be some accountability for Mr. Broder's actions and his addictions. My client tells you that she does work for Steelscape in Kalama. She works from home 3 days per week. She's in the Kalama facility 2 days per week. When she's in Kalama, she does have a paid daycare provider. She pays $50 per day. And then when she's home, her mom comes into the residence. Of course, Dad throws up this red herring about her mom having a history of substance abuse issues. My client tells you, yep, that's exactly correct. She did. That's why I was raised by my father. I didn't have a relationship with my mother because of the substance abuse issues when my client was young. And that's why she's committed to a sober lifestyle, and why she is maintaining that the only time her mom could have contact is if she maintains her own sobriety. She tells you that her mom has been sober for the last 4 years. Her mom has been able to come into the home to help care for Harper while the parties were together. That shouldn't change now that the parties are separated. But obviously, if there were an issue with her mother relapsing, my client would take that very seriously and would, just like with Mr. Broder, would not allow the child to have that contact. If there's ever a case where the sober link monitoring is appropriate, it is here. You have documented substantial history of treatment, failed treatment for this individual. You have an individual in the midst of competing protection orders and a pending divorce, who continues to drink, even though he knows that those are concerns of my client. He continues to smoke marijuana, even though he knows that those are concerns of my client. So we're asking the court to adopt our proposed parenting plan. Technically, given his history, the court should consider Mr. Broder submitting a protracted period of documented clean and sober time before he has supervised visitation. Of course, the court's already sort of rung that bell in the protection order. I guess our position would be to continue the professionally supervised visitation, put him on SoberLink so that we have that consistent testing on a daily basis, so that we know how significant his issue is and if he's going to be able to get control of that. There has been one, I don't know if there's been a subsequent, but when my client filed her reply declaration on June 12th, there had been one exercise professional visit through Reconnecting Families. And that will give additional information from a third-party observer, both to the court and to the guardian ad litem. So we believe that that's appropriate and that the court should adopt our proposed parenting plan on a temporary basis. Mr. Broder, at the time that this matter was filed, worked here locally. He worked Monday through Friday. His work hours were Monday through Thursday from 5:30 a.m. to 4 p.m. and Fridays from 5:30 a.m. to 2 p.m. I am anticipating that supervised visitation should be able to continue to be coordinated. At the time, he was residing in a travel trailer in Kalama, but now apparently he has obtaining new employment without proof of what that financial commitment provides for. And apparently he may be living with his mother down in the McMinnville area. Of course, my client outlines for you concerns relative to his mother. Certainly would not agree that she would be an appropriate supervisor, particularly, again, since he tested positive for alcohol and marijuana following his visitation weekend that the court, after the court had provided for him to do that substance abuse testing. I calculated, as far as incomes for these folks, I calculated Mr. Broder at $5,674 per month net, my client at $4,495 per month net. We're asking the court to order child support in the amount of $907.62 per month, effective May 1. Again, these parties separated on April 14. There has been, other than I'm aware that there was now one $200 payment towards daycare. Otherwise, there's been absolutely no financial support from Mr. Broder to my client since their separation. We're asking that he pay his proportionate share of work-related daycare, uninsured healthcare expenses. We're also asking that the court order him to contribute towards community debt. There is a consolidation debt of $33,784 to First Tech that has a monthly payment of $826 per month. And there's a Community Fiber Federal Credit Union Visa of $130 per month. My client has continued to make those payments. We're asking the court to order him to contribute $500 per month towards those debts. My client continues to cover Mr. Broder on her dental insurance at a cost of $16.50 per month. If she were the vindictive person that he's trying to portray her to be, she would have terminated that. She did not. She also continues to cover him on the cell phone plan, even though we've asked for him to segregate his cell phone from the account. So she's continued to pay that. Our proposed temporary order provides for that to be segregated and each to be responsible for their debts as of May 1 moving forward. We are asking that my client and the children to remain in her separate residence. We provided documentation of that being her separate residence, as well as outlined in our temporary order is the use of personal property in the land.
I just have one question to clarify. Was Mr. Broder aware that Judge Evans was requiring a drug test at that protection order hearing? Or was that, I'm just going to drug test you today and surprise, and the results were positive?
That was requested based on our argument, and the court ordered visitation to be from Friday to Sunday, but if he tested positive for alcohol, the court ordered it to be supervised.
Thank you. All right, Mr. Fuel. Good.
Thank you, Your Honor. Yeah, that's exactly right. The request was made at the hearing. Not that it's particularly relevant, but the court did acknowledge that it was sort of a bit of an ex post facto circumstance. Regarding the parenting plan, I would focus the court on the fact that the evidence seems to show that my client during the pendency of the parenting time with the protective orders were in place or active. I mean, they still are, but pre the order from the court, my client had effectively 3 of every 7 overnights, and both parties dispute that there were issues during exchanges. I think that that's pretty common for what a court would see. I think it's pretty. I don't know that it's completely fair to point all the blame at my client. As you saw in all of my client's materials, yeah, there's an acknowledgement that there's some alcohol, an alcohol situation. He fully anticipates that the court's going to have some sort of hoops for him to jump through. But we'd also point out that there's some legitimate concerns about mom. Now, I don't know that it necessarily means that the court will or even should, change the decision-making circumstances. I don't know that there's any legitimate argument that mom's not the primary. We certainly recognize what the facts are. But even given the previous ruling in the DVPO cases, I'm not sure that there's evidence that supports my client needing his parenting time to be supervised. The court, Judge Evans did express that he would prefer, and Ms. McLean, correct me if you think I'm misstating this, but the effort that was for this to be not professionally supervised. We were concerned, of course, on our side, parties aren't particularly getting along right now. So picking a non-professional supervisor can be difficult in these circumstances. Counsel points out that there's been limited parenting time exercised once it became professionally supervised, and obviously coordinating that, paying for that, all of those things do radically complicate parenting time. My client is perfectly willing to do whatever the court would ask him to do. Obviously, his most his highest concern is maintaining and building his relationship with his daughter. I think that given the facts on the record, I appreciate that the court probably has facts. In fact, probably certainly has facts to support a limitation for my client as far as substance abuse goes. There's a history of that, but I don't know that there's evidence on the record to support any other limitations. As such, we're going to ask the court, again, follow our proposed parenting plan. We're asking for as much as a 50-50 plan. I know that the court's unlikely to do that, even given the child's age, the geographical issues. Those are all complications. But again, outside of those things, I don't know that there's a legit reason to not allow that. Again, given the fact that we anticipate that the court's going to order a guardian ad litem who will certainly shed a lot of light on this thing and probably have some substance abuse hoops for my client to jump through. Before I get to the financial part, Your Honor, the only other issue, and Ms. McLean brought this up, part of their motion is asking for a limitation. My client not be allowed to take the child out of Washington. It is true, and my client's on the call if we need more specific information, but through the pendency of these cases, he has spent significant time living in Washington and across the river in Oregon. If the court is inclined to put some limitations on the where the child can go, we would ask that there be an exception, at least for him to exercise parenting time down at the expanded family residence in Oregon. As far as the finances go, we were, as the court saw from the discovery we provided the court. Again, I know we didn't file a financial declaration, but I think the incomes are largely similar between what counsel filed and what our numbers show. So I'm not going to spend a lot of time on that. I will point out that prior to the child being born, I believe the gross incomes of the parties was about identical. Again, that's not particularly relevant right now for temporary orders, but I think big picture is relevant. And then as far as the bills go, Your Honor, I think I appreciate that it's probably a good idea, again, with the short-term marriage for these parties to start separating their ongoing expenses. I do have if the court is going to have my client contribute to some other bills, I think a 50-50 split on some of these bills is probably appropriate. Again, given what we know the big picture look at these incomes are. I'm a little confused about the respondent's position. I think that I think the argument is for her to pay the mortgage herself on what she's alleging to be the separate property. If that's correct, then obviously we don't object. But again, I just want to nail that down. I don't anticipate that being an issue that we're going to have a long-term issue about as well. So again, Your Honor, I do think that this is a circumstance where we're asking the court to just give my client as much face-to-face time with the child as possible while the GAL does his or her job to give the court more defined information. And I think that's it.
All right, thank you. I appreciate that.
Just briefly, I would point out that our proposed temporary order at paragraph 9A does allocate the first mortgage to my client as the respondent at $1,736 per month. I would note we would ask that the court enter a domestic violence finding, which under the statute would necessitate sole decision making. Obviously, as outlined in our proposed parenting plan, we're proposing that the parties engage in the Our Family Wizard program as far as exchanging information and communication relative to the child. And I think that that is appropriately provided for in our proposed parenting plan at paragraph 4A3. In regards to the his move, again, it's sort of a moving part of him moving down to Oregon. The treatment plan or the evaluation dated May 23rd of 24, so not even a month old yet, indicates on page 1 that the patient will be receiving care in Washington. So again, he's here for all intents and purposes based on that representation. We do believe that the court should limit him from removing the child from the state of Washington and that visits remain at this point professionally supervised. And then as far as incomes, he is $1,200 a month greater than her on net. She has 2 children that she's providing for, and he has not provided support other than that $200 at this juncture.
All right. I'm going to just work my way through some of these orders. Some of them I will be able to adjust based on what I'm going to do. Some of them I won't. So we'll go through those. In the temporary family law order, that was on top, so I'm going to start there. It does seem to be a proper division that petitioner will possess the vehicles that are currently in his possession, which is listed as a 2015 GMC Sierra, an 18-foot boat and boat trailer, and the respondent will possess and be financially responsible for a 2015 GMC Yukon and a 1969 GMC. The mortgage will go to the respondent, the GMC Yukon to the respondent, and the GMC Sierra to the respondent as far as payment wise. Childcare, I think, should be proportionally split between the parties. And I do think 50-50 on the community debts, which are the First Tech personal loan and the Fiber federal loan. So I will enter this family law order as presented.
And Your Honor, at paragraph 4C is the language about not removing the child from Washington State. I'm just pointing that out because that was argued by counsel.
Paragraph, I'm sorry, where?
4C.
4B.
C as in cat.
B. Okay. I'm gonna strike that because I'm gonna take care of that somewhere else.
Okay.
So 4C, I am removing, otherwise entering the temporary family law order. The next step I have is the restraining order. I've reviewed this. It is pretty basic, so not to disturb the protected party, go onto the grounds of the protected party, their workplace, vehicles, school, daycare, and to remain within 500 feet, and no assaulting, harassing, stalking, use, attempted use, or threatened to use any physical force. I'm going to grant that with no alterations.
Would the court please mark the first box on 4, indicating that he was present for the hearing?
I have marked that box.
Thank you.
If I could get the next three names for guardian ad litem.
The next three names are Amy Turnbull, Heather Hill, and Ann Height.
All right, so Amy Turnbull, Heather Kale, and Ann Height.
I don't have any objections.
Neither do I, Your Honor.
All right, so we'll appoint Amy Turnbull. And I have the, it says 30-day review, July 9th. We set this over, it looks like this was set over 1 week. I don't know if you want to bump those dates each back a week.
My preference would be not to, because I'm going to be out of the office starting July 12th through the end of the month.
All right, so we'll keep
And that's just to see if the parties have been in contact with the GAL and if they've paid their fees.
We'll keep that date then as is. And if we need to move the other date, we can worry about that later.
I'm sorry, which other date are you talking about, Your Honor?
There's a review date in 30 days just to ensure that the parties have met with the GAL or made contact with them, returned the informational packet, and have paid their fees. And that's for July 9th, 2024 at 9 a.m. And then there's a final GAL review date of October 22nd, 2024 at 9 a.m. I don't know what is going on. Sorry, there's some kind of construction noises happening here. And they are gotten increasingly louder, and I don't know if
we can't hear them on our, or at least I can't hear them on mine.
Well, good. You're lucky. I can't imagine what that noise is. All right. I've reviewed the proposed child support worksheets. There's some differences, but I think the parties are relatively close in wage. I didn't see, let me look here. I just cross-reference something here. And I'm assuming, Mr. Fuel, that your client, even though he may be living part-time in Oregon, he's still working with the same.
That's my understanding, Your Honor. Yes.
Okay. All right. I'm going to ask parties to hold on 1 second. So in reviewing the financial declarations that were submitted by Mr. Brodeur and what was submitted by Ms. Doble, I'm going to enter the child support worksheet that was presented by Ms. McLean. So the party's income is set at a gross income 7388.10 for Mr. 5645.50 for Mrs. Which puts child support at 907.62. The parenting plan, I am going to reserve on a lot of 191 factors. I am not reserving on substance abuse. So I am going to neglect will be reserved. Child abuse reserved. Emotional physical problem is reserved. Substance abuse, I am going to make a finding based on the information provided. Abusive use of conflict is reserved. I do have some concerns. I did review the information that was submitted. One of the comments that and I guess I appreciate that Mr. Brodeur is being honest with his healthcare providers and in his SUD evaluation. But the presenting problem as described in the report is I'm in the middle of a divorce and I feel like it'll look better if I'm engaged in some sort of treatment before going to court. Clearly there's an alcohol problem here. It appears to the court if he's coming off a visitation and testing positive for both alcohol and marijuana. This child is 8 months old, in that range now, still breastfeeding. One of the concerns when I reviewed everything was the week on, week off, and the complaints about running out of breast milk, and the dad would have to come back from Oregon. And I don't know how reasonable it is to believe that mom can just be a milk factory to have enough stockpile to have dad leave with the kid for a week for visitation and go to another state. I do think some layers of protection need to be imposed here. There's a lot put forward in Ms. McLean's request here, including the requirement of 3 months of sobriety before any visitation resumed. I'm not going to go there. I'm not going to go that extreme here, but I do think that there needs to be some layers of protection. So this is where we may need to have a new order drawn up. I'm going to list as primary custodian, Ms. Doble. I'm going to require that Mr. Brodeur partake in another SUD evaluation with collaterals from Ms. Doble and the GAL, though the GAL may not have a whole lot of input, depending on how quickly that's done. I do think at this point, supervised visitation is appropriate. And if the parties, I guess, Mr. Fuel, you touched base on this briefly, but what is the thought of coming to an agreement on a non-professional supervisor? I know there's concerns with that, but.
Well, sorry. Yeah, Your Honor, the only issue is that these parties not only are restricted from communicating directly with each other, although I know that this court will make some accommodations for that. Not only that, but there's currently a pretty decent level of distrust between all parties. We sure tried, I think, between Ms. McLean and myself to come up with somebody. I think we were suggesting my client's father, since mom had a concern about my client's mother. I mean, as this court knows, I mean, it's going to be a significant roadblock for these parties to be reliant on the supervised visitation. I know that the court's position is largely it's my client's substance issue, and not entirely. That's the basis for that. And I understand the court's position there, but obviously parenting time is for the child. And this is a child who's seen dad up until these orders got put into place almost 50-50 time. Again, I know they lived together and then it was 3 days, 4 days. So not precisely 50-50. I don't want to overstate it, but as the court sees, once the supervised parenting time became a professional supervising situation, the parenting time drastically reduced because it is cumbersome both in time and expense. And so I would just urge this court to if we can figure out a way to find somebody who's not going to be have limitations on when they can do it, or limited limitations, and also not have limitations on the expense, because this is again the parenting time is for the child, not for the parents. And this is a situation where, while she obviously deserves and needs to be safe, thus far I'm not sure there's a lot of evidence that she hasn't been while she's been in my client's care. I don't know how responsive that was, Your Honor. I apologize.
No, that's okay. It's a tough question to respond to. And does your client's father reside in Oregon?
Your Honor, my client's on the line. He might be better suited to ask some of these direct questions to, if he can hop on. Mr. Broder, are you there?
Hello, Your Honor.
Mr. Brodeur, good morning. Does your father reside in Oregon, or where does your father reside?
All of my family resides in Oregon.
And what town specifically?
McMinnville and Newburgh.
McMinnville and Newburgh. Thank you very much.
Yes.
We have Mr. Fuelback. Ms. McLean, do you want to respond to that question?
Yes, it was my understanding that his father resided in Oregon. Under the protection order, his father was providing the transportation, which obviously causes some concerns, given the fact that he's delivering the child to Mr. Broder, who is at some point during that visitation time engaging in substance use. As my client has indicated, there's concerns relative to Mr. Broder's mother, who apparently runs a daycare, and my client has observed adults consuming alcohol during daycare hours and with third-party children present. So there are some concerns there. I think it's appropriate that we have a level of at least professional supervised visitation here for a period of time. Otherwise, I can also check with my client to see if she has family that's available, since he does work here in Kelso. So I could check with her and see if she has maybe her mom or dad that would be able to do that supervision if the court deemed appropriate.
Okay, I appreciate that. I want to keep going through the parenting plan here. Obviously, both parents are restrained from any negative discussions or third-party negative talk about the other parent to the child. They need to participate in Child in the Middle. I think that is an appropriate class for these parties. And Our Family Wizard, I think, is also an appropriate communication tool for the parties. So I'll order that. With the evaluation that Mr. Broder needs to undergo with collaterals, I do think that those evaluations need to outline any recommended treatment. A copy of that evaluation needs to be provided to opposing party and to the court, along with any treatment plan and UA tests. And I think we need to continue to get copies of those UAs as treatment progresses. What I'm going to do is I'm going to order for a period of, I guess I'm not going to set a specific time, but I am going to order supervised visitation. If the parties can agree on a layperson to do that, then that is absolutely, I think, the best thing. If they cannot agree on a person to do that visitation, then those would be professionally supervised. So at the very minimum, I'm allowing professionally supervised visitation with the hope that there can just be a supervised visitation by a layperson agreed by the parties. I do think the decision-making as outlined at this point anyway is appropriate. So I'm going to leave that as requested by Ms. McLean.
Is the court ordering, I'm looking specifically at page 3 of our proposed parenting plan in regards to alcohol, the request for a random alcohol or substance testing, that he's to be restrained from being under the influence of or consuming alcohol, legal or illegal drugs except as prescribed by a provider, and not engaging in any corporal or physical punishment.
Yes.
Okay.
So B and C. And
okay.
This is subsection 4B 2. I will adopt 2A, B, C.
So the court is not adopting the sober link.
I'm not adopting sober link at this point in time. What I will say directly to Mr. Broder is if there is a problem and we have any dilute UAs, any UAs that are compromised, any failure to take UAs when you're supposed to take UAs, then sober link will be the very next step.
So could the court just indicate that that's reserved?
So that's fine. We'll say reserved. Okay. And there would be those triggers for utilizing that program. So B under 5B would be number 1. So the limitations in decision making are based on the substance abuse as outlined in B1C. As I stated, Ms. Doe will be the primary. And Mr. Broder, let's see, let me pull up. I think I had your work schedule in here.
Your Honor, I'm sorry. Just before we get too far down on other parts of this parenting plan, so the court's ordering that my client do an evaluation, treatment, any testing that the treatment provider requires, but then also any testing that mom requests as well.
Correct. And mom would pay for that, assuming the UA is clean.
Okay.
So that language that's proposed by the respondent. All right, and then to help expedite this, Mr. Fuel, your clients, and I know I saw it and I just didn't make a note of it. What's his normal work schedule?
Okay, yeah, Your Honor, my client at this point is pretty flexible with his schedule, but it is Monday through Friday.
Okay. So I'm going to allow for in this supervised visitation interim, and Ms. McLean, just before I do this, your clients, I know that was included somewhere as well, and I didn't write it down. What is her work schedule?
She works from home, and she's going to correct me if I'm wrong, but I think it's Tuesday, Thursday, Friday she works from home, and Monday from Wednesday she's at Kalama. So the child is with a daycare provider within the home those 2 days, and then otherwise her mom's in the home Tuesday, Thursday, Friday with her.
Okay, so would Monday and Wednesday be preferred? So she's not home if for those.
That would probably be less amenable to. I think my client would have more flexibility if visits are on Tuesdays, Thursdays, or Fridays.
Okay. All right. So I'm gonna allow for up to 4 hours of supervised visitation a week.
Okay.
An entire week, Your Honor?
I'm sorry?
In an entire week?
In an entire week. So every week he gets up to 4 hours. Once we have 60 days of sobriety, then the court will move to looking at first, third, and fifth weekends. Excuse me.
Bless you.
And those, at this point, without any further information, I guess I don't want to assume anything, and I don't want to assume that Mr. Brodeur's family would be a bad influence on him or anything as far as drinking and whatnot. Barring any other information about the family in McMinnville, Newburgh, those weekends would allow for the child to go to Oregon to that family complex or compound, whatever. So once we get 60 days of sobriety, we'll start weekends, first, third, and fifth, beginning Friday at say 5 p.m. to Sunday at 5 p.m.
And that's where we had the difficulty before with the breast milk. That's why Judge Evans had ordered the return time or the exchange on Sundays at 9 a.m.
Well, Your Honor, this is going to be well down the line. And so our argument would be that at this point, especially if it's only going to be 2 days, that's something that hopefully mom can be prepping for between now and then. Again, the parent, as the court knows, the parenting time is for the child. And at this point, we're taking a huge chunk out of what this kid's used to with dad.
Well, the kid's 7 months old, so I appreciate that, but I think Friday to 5 p.m. to Sunday to 5 p.m. is sufficient. Providing 48 hours of breast milk versus 7 days worth of breast milk is entirely different.
Understood.
And
agreed.
This is after 60 days of sobriety. So my hope is that 60 days from today, but you know.
And Your Honor, any midweek time? Again, once we get to the 60 days plus.
Ms. McLean, you want any response there? Or?
Well, again, given the fact that there's a restraining order in place and sort of the logistics of everything, at this point, I would ask that the court allow the GAL to weigh in on any of those concerns.
I will reserve on midweek time. And then at this point, I'm not going to go beyond essentially these 2 steps. So 4 hours supervised a week until we get to 60 days of sobriety. Then we move to 1st, 3rd, 5th weekends with an approval to go to Oregon with the child. And I don't know if petitioner's dad is transporting because was there a specific reason for that, or is there something in the protection order about?
It was due to the protection orders.
Okay, so whatever, clearly there was a reason for that, so that would still be the case. So any transport of, if the protection order is still in place, the transport would still need to be done by, I guess, child's grandfather.
I think those are going to lapse as of Monday, I think.
I think it's a week from Monday, but I think otherwise that's correct. So, Your Honor, if presuming that that's not a limitation, is this court ordering any limitations on the transport?
No.
Thank you.
And
at this point, I'm not going to address a summer schedule because I think, well, for a couple different reasons. One, the age of the child. 2, I think we'll be through the summer by the time we get through the 2 phases, and hopefully we'll be getting close to getting some information from a guardian ad litem, getting those evaluations back, and having some additional information to move forward with. Yes, Ms. McLean.
As far as the 60 days of sobriety, I'm assuming that's documented sobriety.
Yes. So through, this isn't personal time. Obviously we appreciate and respect personal time, but this would be documented and through any treatment provider UAs and including any UAs requested by the respondent. Okay.
All right. So I'll make those changes and get that proposal to Mr. Fuel. Is the court opposed to setting up a presentation date if we need one?
Absolutely not. I'm still Fridays at 8:45. I will tell you that I am not here Friday, July 5th, and I'm not here the 12th, and I'm not here the 19th.
Could we do June 28th?
Absolutely.
What time is that docket, Your Honor?
It is 8:45 a.m. and it just would be, I think it's Judge Fassett presentations is what it's called. So it's all by Zoom. And Friday, the 28th of June at 8:45.
Okay. Yeah, I can do that, Your Honor.
All right. And
if necessary.
We can strike it if we reach an agreement.
Yeah, by all means, you can strike that, but we'll set it now just as a fail-safe. And then if you reach an agreement, I'll sign the rest or that parenting plan once it's presented.
Thank you.
All right. Thank you. Good luck.
Thanks.
Thank you, Your Honor.
And I believe that's all we can go off the record.